Good morning, everyone. Thank you for joining us here today for the very awaited lecture series on Guide to Commercial Codes Act 2015. I, on behalf of the Placement Assistance Council, extend a very warm welcome to our esteemed speaker for the lecture series, Advocate Rajat Mathur, sir. It is an absolute honor for me to introduce you, sir. Sir has graduated with honors in BCom from Sri Ram College of Commerce in 2007. He then obtained an LLB degree from our very own University of Delhi's Faculty of Law in 2010. He then went on to do his diploma in intellectual property rights from London School of Economics. Sir has more than 10 years of experience in litigation and commercial practice. He has handled numerous high-profile cases and has worked with several senior counsels like Senior Advocate Harish Salve and Senior Advocate Siddarth Luthra. Some of the important matters Sir has extensively worked on include the Coal Scam Allocation Trials, the 2G scam case, Lalithakumari Constitutional Bench matter, the Makwana Mangaldas Tulsidas versus State of Gujarat for speedy disposal of check bouncing cases under Section 138 of NI Act 1881. The glorious list of matters Sir has worked on is indefinite. I'm certain that we all have a lot to learn indeed from this lecture series at today's and tomorrow's sessions. Before moving forward, I would request you all to raise your hand if you happen to have any questions in between, or you can type your questions in the chat box. So without any further delay, I would like to call upon our teacher convener, Dr. Ruchita Chakroborty, to enlighten us with your valuable words on behalf of the entire Placement Assistance Council.
Thank you so much, Kuchotika. So I wouldn't take much time because I think it is time that we learn some new aspects of law, because commercial courts happens to be that field of law which we do not teach in the campus law center still. So I think this is going to be an extremely enlightening session for all the students because of its relevance and of course because of its practical applicability. And of course, what I would like to share today is I'm extremely elated and happy, and I would like to extend my warm welcome to Mr. Rajat Mathur. Thank you so much for accepting our invitation, for taking out time from your busy schedule to arrange this lecture series. And students are really waiting for your enlightening session so that they can understand this law. They can because most of us, as we know, that campus students at the campus law center, they have an insight towards practice, and they like to go to the litigation. And this is one that law that is extremely important while students would like to go for practice, especially given the IPR laws, the NI cases, etc. So without wasting much time, I would like to welcome to you on behalf of the Placement Assistance Council, Campus Law Center. You can please start the session now, Mr. Mathur.
Thank you so much, ma'am, and for the warm welcome. This act is, quite important. We'll, just to give a heads up, we will have we have broken the today's lecture into, various aspects. The first being that I will discuss and start with the flow chart of the various stages of a civil case, and that would also include on the commercial side. The second would cover is the Bear Act as a whole, and also the rules contained therein in the Commercial Codes Act, which came into effect on 23rd of October 2015. Thereafter, I would discuss the crux of the issue as to what is the meaning of a commercial dispute, and would also refer a few judgments of Delhi High Court, just to have the interpretation clear as to what is the meaning of the commercial dispute. Because remember, that would be very important when you file a commercial suit or an ordinary suit or a summary suit. So that distinction and the importance of the interpretation would help you in determining where you file your suit, which court, and at what level, with what pecuniary subject matter. So that is very important. Thereafter, I would refer to a present ongoing case, which I'm doing on the copyright commercial, that is a commercial suit in a copyright matter. And, with the help of the online system, which is now going on, I will refer that the entire suit as to what contains in that suit, what are the various annexures, what are the applications, and so on. Thereafter, I will refer to the one draft of a copy of the written statement, which is filed in this very case, and thereafter I would refer to certain connected issues which are also part of that ongoing case, so that you all get a heads up as to what it takes to pursue a civil suit at what stage, and what are the important parts that you need to consider while most importantly drafting a suit. Because one you need to remember that while you draft a suit, the preparation doesn't end there. It actually starts. So you have to conceive the entire suit till the end in terms of the stages, and then only you draft it, and also you collect documents and also the evidences as to who will be the witnesses who will prove XYZ documents which are filed along with your suit. So you need to strategize very properly, and this entire exercise has to be done before you file a suit and not after. Generally, in we see that this application of mind happens after the filing of the suit, and it should be avoided. So that is the crux and the sequence of today's lecture. So we'll start with the flow chart of a civil case as to what happens, what are the various stages, so that when I refer to that case law, case study, the students, you all can actually correlate uh, where this suit is is pending at the moment. Just open Mayank, the flow chart. Yeah. So in the flow chart, as you can see, you draft a plaint, and when you file a plaint in the court, it gets a filing number, right? When it gets a filing number, it becomes a suit, right? So when you file a suit, the suit is filed by the plaintiff, and that is why the word plaint, you know. And thereafter, the as per the mandate, 30 days is time. 30 days time is given to a defendant who is on the opposite side, who files a written statement, oblique reply to the plaint. Plaint is basically pleadings. Plaint, the suit. Now that you have a suit number, the suit consists of your plaint, which is the pleadings. Pleadings is discussed in order 6, if I remember correctly, of the CPC. Uh, Thereafter, the plaint has to be proved by documents. So there will be a list of documents. After, there has to be a list of witnesses who will prove those, and that is the some broad 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 summary of the suit. So when the suit is filed, uh, then the opposite side, which is the defendant, has to reply within the time mandated under CPC, which is 30 days, which is extendable to 120 in extreme circumstances as provided therein. Thereafter, uh, just before that, this flowchart, also details that the summons, when the plaint is filed and the suit is numbered, then the on the first date, the summons are issued to the opposite side, defendant, and pursuant thereto, he appears, the defendant appears in the court, and he WS. He has to file WS within 30 days. Thereafter, as per the pleadings, the after the WS, the plaintiff, in reply to the WS, has to file replication. And after the replication, in reply to the replication, the defendant in turn has to file rejoinder. I'm going a bit beyond this also, because that is on the practical side. Even though rejoinder and replication may be mentioned, but rejoinder, there is no provision in the CPC. So after the rejoinder, then then there's a stage, very important stage, very make or break situation stage, is admission denial affidavit. admission denial affidavit is very important for the fact that, let's say, the plaintiff has filed six documents, right, and defendant has also filed a few documents. So both the parties have to admit or deny on affidavit their respective documents, and the documents which are admitted by either party, those would be kept aside. Those technically will not be the subject matter of the suit, because remember, a suit is being it runs on disputed facts, right? And to prove facts, you have to produce documents, and if the documents are admitted, then it doesn't become a subject matter of the trial. Now, the documents, after the both the parties, respective parties, admit or deny each other's document, then on the remaining document, let's say plaintiff filed six documents, defendant filed two documents. Plaintiff denies both the documents of the defendant, and defendant denies five of the documents and admits one document of the plaintiff. So therefore, the one document which was denied by the plaintiff, by the defendant of the plaintiff, let's say document number one, and plaintiff having denied both the documents of the defendant. So on two documents of the defendant and one document of the plaintiff, those issues, on those facts read with the documents, the issues will be framed. Issues basically is, for example, plaintiff filed a suit that plaintiff has to recover 15 lakh rupees from defendant. Now, this is the fact in issue or the moot issue, fact in issue as per the Evidence Act, and in common parlance, you may say the crux of the issue in a particular suit. Now, as per the Evidence Act, the party who alleges a fact or alleges is a more on the criminal side. On the civil side, a party makes an averment of a particular fact. Then, as per the Evidence Act, the onus is on that particular party to prove that fact, right? So, after the admission in that stage, you will have the stage of framing of the issues only on the disputed facts. Disputed facts. Now, I gave you the example of the admission denial. Now, I gave you the example for the issue. Now, the issue is whether plaintiff is entitled to claim 15 lakh rupees from defendant. In the reverse, whether defendant is liable to pay 15 lakhs to plaintiff. Now, the issue in this case will be framed as whether plaintiff is entitled to a recovery of 15 lakh rupees oblique as part of the decree in the present suit. A question mark. Then, you guys must have done the internships. There you may have seen in the issues frame after the question mark OPP. OPP is onus to prove on plaintiff, because plaintiff wants that fact to be proved, and hence he has asserted that fact. So the onus is, so let's say there are two issues. One issue is first, whether plaintiff is entitled to recovery of 15 lakh rupees from defendant, question mark OPP. So this will have to be OPP. OPP means onus to prove on plaintiff. Onus, as per the Evidence Act, the party who alleges or the party who averts a fact, the onus is on that particular party to prove that fact. So on the first issue, which is the central issue, onus is on the plaintiff. Thereafter, the second issue, let's say in this case, defendant makes a counterclaim. And he says, no, instead, plaintiff owes me 20 lakh rupees. So this is a fact which defendant averts in his written statement. So therefore, the onus is on the defendant to prove this fact. So the issue number two would be whether defendant is entitled to 20 lakh rupees as counterclaim from plaintiff, question mark OPD. OPD means onus to prove on defendant. So this exercise is very important. Now, just a moment to pause here. The reason why I said that you have to conceive the entire matter in the entirety before even drafting, That is very important. Before you even start drafting a case, you have to conceive the case. You have to speak to the client, notice a version entire in front of you, know the documents, what he says, what proof he has, what witnesses he has. So all these things, this exercise has to be done priorly and not after the filing the suit. The reason is once you start, once you draft a plaint, these all contingencies which will arise at the stage of the admission denial, oblique framing of the issue. These all have to be conceived priorly and not afterwards, or else you would be you would be in a soup. Now, at the time of the one step behind, I refer to admission denial. So, as a plaintiff lawyer, if you need to recover that money and you want to successfully prove that issue number one in your favor, you need to strategize that which document should I deny of the opposite side, how do I deny, mode of proof. अब उसको proof कैसे करोगे? Proof has to be by either the plaintiff has the original document. Let's say he had some document wherein a defendant admits in writing on a piece of paper that I owe 15 lakhs to plaintiff. Now, this document is original document, or it can be photocopy document, or it can be certified copy. So these are the three modes. Now, original document, when you discuss, I will revert back to the stage of pre-drafting. When you sit with the client, you ask him, okay, a plaintiff says that I need to recover 15 lakhs. So you will ask as a lawyer that what is the document on the basis of which you are saying? Where is the document? Is it a photocopy or the original? Because if I am there from the defendant side and the plaintiff files a photocopy of that original document, then as per the Evidence Act, I will raise an objection before the court that it can't be exhibited. I will keep on referring to these terms, exhibit and mark, because I will also deal with them separately. So, in order to prove your suit, one plaintiff needs to have original documents as best evidence. So the lawyer needs to be very particular. He has to collect those original documents. He has to collect those witnesses who are party to that document, who will prove that document. Now, in this case, as the document was referred, that in which the defendant acknowledged in writing with his signatures, and plaintiff is also party to the document. So the document is basically proved either by the author of the document or a person who has personal knowledge of the document. So in this case, plaintiff will have personal knowledge and also is a party to the document because he must have signed along with the defendant. So this, and also just keep in mind when the issues are framed, the practical exercise in the court happens is court will say, okay, the admission denial affidavit is filed by both the parties. Court will summarize that which is the disputed fact now remains, which which will undergo trial, and then the issue will be framed. Before the issue, the framed, the court generally asks both the sides that you bring your on a piece of paper, you bring your tentative issues that you want the court to frame it. Now, in that exercise, there you have to be very particular in what issue you put what onus. Now, the better understanding would be that as far as possible, the fact which you are, the fact which you want the court to be, the fact which needs to be proved, and which you assert it, if possible, if you can put the onus on the opposite side in that issue, and you write in the first issue as I referred, OPD, then the onus is on the opposite side. So that is very important. And as a lawyer, you have to be very particular in that exercise that you don't allow wrong onus to be put on a particular issue. Let's say in this example, the defendant lawyer is not very careful, and I am there for the plaintiff, and I put on both the issues OPD. Now the consequence of that is the onus is there on both the issues. Even though on the first issue, if you recall, I had framed the issue was whether plaintiff is entitled to recovery of 15 lakhs. So in a on a fact which I want it to be proved, and I put the onus on the opposite side, then that is a very grave error on the part. And if the court also doesn't point out, and you are better off not to point out, then in the trial the defendant will suffer because he has to prove now both the issues, including the first issue which which the plaintiff was supposed to issue. So this is very important. So on every stage, so let's say in a civil suit there are 10 stages. So before you file the case at the stage of drafting, you have to analyze the entire case, and you see towards the end of the tunnel that what is the standing point, final standing document, final standing witness, what is the law on the 15 lakh rupees, which court you will file, before the hierarchy of the court. So that is very important. So, that the entire sequence is very important. So the next stage after the, issues are framed, then your actual trial starts. So in the trial, what happens is, the plaintiff will file his plaint in the form of affidavit. That is called evidence by way of affidavit. Plaint. So when you draft again you have to conceive very carefully. When you file an affidavit, which will be subject matter of the trial, on the basis of which the cross examination will happen. So the affidavit in the plaint converted into an affidavit in the form of precise word is evidence by way of affidavit. So basically the उसमें drafting में difference बस इतना होता है that plaint में when you draft you write that plaintiff is entitled so and so, plaintiff is that plaintiff is resident of so and so, that valuation of the suit is so and so, that jurisdiction is so and so. That becomes I in the evidence affidavit. It will be in first form. You write I, the deponent states so and so. I, the deponent states so and so. Right. So before you draft again the evidence affidavit, you again need to summarize the entire suit in your mind, conceive, and then you draft. Meaning thereby you conceive in your mind plaint. WS is it's in a sense it is like mathematics. You basically have to cut the facts against each other, because in WS you say I deny X fact, I deny X by fact, I deny Z fact of plaint. So let's say plaint has 10 material facts and defendant denies all of them, saying I deny in toto, I specifically deny. So which means mathematically, in for a better understanding, all the 10 facts which plaintiff said is true, you say it is not true, meaning thereby that plaintiff has to prove his own case now. So when the issue will be framed, just forget about those previous issues. If 1 to 4 issues are framed on the basis of those 10 facts, the defendant has to be very careful. The onus on all those issues is on OPP, because you have denied those facts. So basically you have denied, and the onus shifts on the plaintiff to prove those facts because he has averred those facts. So that is how the onus is very important in a civil case. The smartness is that as far as possible, you put as a defendant onus on the opposite side. So which is why the drafting of the written statement is very important. Again, on the converse side, as I said, for the plaintiff side, defendant side need to know his version in response to the version of the plaintiff. One possible version can be, as I gave the example, plaintiff says, I have to record 15 lakh rupees. A defendant says, instead, plaintiff owes me 20 lakh rupees. So 5 lakh more he owes me. Now, as a defendant lawyer, I will ask him what document you have. and defendant says me, I have the original copy of a document signed by the plaintiff wherein he says defendant has given 15 lakh rupees. Plaintiff had taken loan of 20 lakh rupees from defendant, and he admits that in writing, date, signature, and the document with the this document is with the defendant. Now, when you drafted a WS, you deny all those 4, 5, 10 facts in the plaint, and you put your version before the court in the form of plaint that he's not stating correctly. Instead, he owes me 5 lakh balance. And you annex the document, original document, along with your written statement. And when the admission denial takes place, if your document, your means defendant document, is denied by the plaintiff, then in that case, onus on the document to prove that counterclaim will be on you. So on that particular issue, the onus will be OPD. So this is how it goes. So or on the criminal side, there is chief examination. On the civil side, you have chief examination in the form of affidavit. Now the distinction is, in a criminal case, chief examination happens orally. Let's say in a murder case, prosecution is the state and a defense lawyer is for the accused. Now there the procedure is, when the trial starts, the chief examination, the main witness to the crime who says, I saw accused committing murder, he will come and depose orally in the court. This is on the criminal side. There's no affidavit, there's no written statement, or there's no written form of chief examination, as opposed to on the civil side. Now on the civil side, the chief examination happens in the form of affidavit, and then the defendant has to cross-examine. So plaintiff will file the chief examination, defendant will do the cross-examination, and vice versa. Once the plaintiff concludes his evidence, then the order sheet will say PE, plaintiff evidence is closed. Now the defendant is at liberty to lead his evidence, and defendant evidence is called DE capital. Now then the defendant will prove a defendant will now proceed to prove his part of the issue. Let's say issue number 2 is OPD. Now the endeavor of the defendant would be to prove that OPD, and whatever documents he has filed in the WS, he will refer that, and the WS will be converted into form of an evidence affidavit, which is oblique chief examination. If you compare on the criminal side, chief examination, defendant, plaintiff will do cross-examine, and whatever the evidence, and after the conclusion of the defendant evidence, the order sheet will say defendant evidence closed. Now the matter put up for final arguments. Now, as you see in the flow chart, then the final arguments will happen. As a plaintiff lawyer, final arguments will consist of right from plaint, replication, his version. I'm now segregating the version, plaintiff and defendant device. Plaintiff, plaint, oblique suit, replication. You see admission denial affidavit, what happened, issues, and then you minutely peruse your chief examination of your evidence. Now you will have to determine whether, on the basis of the chief examination, whether in the cross examination, defendant is able to break through your chief examination. If he's able to break through, then plaintiff is not. Then the conclusion would be plaintiff not able to prove issue number 1, therefore suit dismissed. On the converse, on the basis of the chief examination, the cross-examination done by plaintiff, leave apart the defendant evidence. I'm just going step by step. Leave apart the defense evidence. Strictly on the plaintiff evidence, if the defendant is not able to break the facts as sought to prove by the plaintiff, then the result would be issue number one proved by plaintiff, and therefore suit decreed. After the matter will go for the execution. That is a separate part. Now take one more scenario. In the plaintiff, in the plaintiff evidence, defendant, since he has blatantly denied, and he doesn't put his version on the record in the trial. In the defense evidence, he also doesn't bring any substantive document. He simply say deny, deny, deny. So his exercise of defense evidence will be a futile exercise. On the contrary, if let's say plaintiff, makes a very simple version in the plaintiff evidence, a defendant makes a very simple version in the plaintiff evidence and says that I deny whatever you said in the chief examination. Now let me come to my evidence, and he's able to demonstrate through documents that he actually plaintiff in fact defendant in fact gave a loan of 20 lakhs which surpasses 15 lakhs. So then, if defendant through his defendant evidence is able to approve his second issue, which is a counterclaim issue, OPD, then the net conclusion would be that plaintiff, the issue number one proved by the plaintiff, which is 15 lakhs. Issue number two proved by the defendant. Net summation is plaintiff had to take 15 lakhs, defendant had to take 20 lakhs. Net summation would be that 5 lakhs plaintiff has to pay to the defendant. So that is how the case goes. So make or break situation would be how you frame the issue, your mental application at the moment when it is framed, admission denial, and of course your cross examination, which is the most important tool, because no matter what you do everything correct, and you don't know how to cross examine and how to break the plaintiff witness, and on the contrary, plaintiff lawyer doesn't know how to break the defense evidence of witnesses through his cross examination. It would be futile exercise. Ultimately, if your version does not come on record through cross examination on the evidence in the court file, you may lose in a particular case. Even though you have a good case, you may always challenge, and the first question the high court will say, or the appellate court will say, where you have put your version in the evidence, show me that particular line, particular page. So that is very important. Your version should come on record in writing in evidence. If you don't do it, if you don't perceive that, you can't file an appeal and say, the first question the high court will say, where have you said this question in the evidence? Show me that page. And obviously you didn't take that question. You didn't put that question in the evidence. It's only your after recollection that you should have put that, but that won't help. Court will go strictly by the record. So it's basically, you are a potter, you give shape to a pot, and that if once that shape is given through the trial court, the first court, where it is a court of record. Trial court is court of record. So you have to be very careful and put your version in the record. High court is a court of appeal. You can't add or substitute a document. The mistake you made in the trial court, you can't say in the high court said that I should have asked that particular question in the evidence or in the cross examination. Therefore, now you permit me to argue on this point. So court will say, I appeal. In appeal, court will not go beyond record. If it is part of the record, it's fine. If it is not, then you're out. So that is the brief summary of it. Now I will, come to I've taken actually a bit more time because this stage is very important. So once you understand, this stage, you will understand the case, that case law which I will refer better. Now I will, quickly move to the sale number 2, which is the Bear Act. This came into effect on 23rd of October 2015. Basically, earlier the pecuniary jurisdiction was of the trial courts were 20 lakhs, right? And which was increased to 2 CR. So when you file a suit up till 2 CR, it is before the trial court, whether it is on the original side, on the ordinary side, or on the commercial side. And beyond 2 CR, you have in the High Court. Now, to summarize the entire Act, Commercial Courts Act was brought into picture because of the commercial transactions. A legal system of any country, if the commercial matters, commercial transactions are expedited, then that gives a very positive signal to the investors oblique the FDIs. So that was the larger purpose, and thereafter the distinction of the courts in this act discussed are basically there are 4 types of courts. Commercial court. If you mind, you can just go through the initial chapter 2. This chapter 2 basically deals with commercial court. Then you have commercial appellate court. Then you have commercial division, which is the High Court, and commercial appellate division, which is the division bench of High Court. So we have 4 courts, being broad subject matter of this act: commercial court, commercial appellate court, which is both the trial court, ADJ. Just before that, the hierarchy of the courts. You have civil judge, you have senior civil judge, you have ADJ, then you have district judge, you have High Court, single bench, High Court, division bench, Supreme Court. So this is the broad hierarchy. So on the Commercial Courts Act, as I referred to 4 courts: commercial court, commercial appellate court, commercial division court, commercial appellate division court. So the first 2 courts, commercial court and commercial appellate courts, pertain to trial courts, ADJ and district judge. Then commercial division is the High Court single judge bench. Commercial appellate division is the High Court division bench. And same is the appeal scenario. The first court, the appeal from the court, as that particular provision I've just referred for the appeal part. For the appeal part, section 13 says, just just scroll through the section 13. Yeah. Next. Section 13, if you see 1 to 1 proviso 2, it basically says that just keep in mind the 4 courts: ADJ, DJ, High Court, single judge, High Court, division bench. So there are 4 category of courts. Now this section says the appeal from the ADJ, which is the commercial court, first court, will go to the next second court, DJ court, which is the commercial appellate court. Thereafter, within 60 days, the appeal from the second court will go to the 4th court. Second is the DJ court, 4th is the division bench, High Court. And from the single appeal from the single bench, High Court, which is the commercial division, which will go, of course, to division bench. So, to summarize, ADJ level, the commercial appeal, the appeal will go to his superior, district judge. From district judge, the appeal will go to division bench, High Court. From single judge bench, appeal will go to division bench. So this is the scenario of the appeal, and in all the appeals, the period is 60 days, specified in the act, right? And the appeal provision is section 13. So this is the appeal, the mechanism, right? Now we next come to section 3.A, section 4 and 5. Now these 4 sections, section 3A, which is not there, but which was added subsequently by this act. Section 3A capital 4 and 5 deals with 4 courts, as I just mentioned: commercial court, commercial appellate court, commercial division, which is the single judge, commercial appellate division, which is the division bench. Now 4 courts. The interplay of the appeals I've given you. Section 13, the interplay of the period I've also given you. Now may come to section 6.7. Section 6.7 is important when you draft a suit. Jurisdiction of commercial court. Section 6 says the commercial court shall have jurisdiction to try all suits in application relating to a commercial dispute. I will come back to the expression commercial dispute because it is the central to the entire act. I will deal with that in a moment. I'll just scroll through the bare act. Commercial dispute of a specified value. Specified value is section 12. Out of the entire territory of the state over which it has been vested, territorial. Now, just to clarify, jurisdiction has 3-4 categories. Territorial means place. Subject matter means category of the the nature of the suit. The topic of the suit. It is movable property, immovable property, copyright. So that is subject matter. Territorial means within Delhi, outside Delhi, place, right? And you have pecuniary. Pecuniary means the court fees which you will annex or you will append with a suit. Now, as I said you earlier, the pecuniary jurisdiction of trial court up till trial court means civil judge, senior civil judge, ADJ. ADJ means additional district judge and district judge. So these are 4 basically which constitute trial court. So earlier, prior to 2014, the pecuniary jurisdiction of the trial courts were up till 20 lakhs. So much of the matters went to High Court because you buy any property, any claim, normally it used to be more than 20 lakhs. So now it has been changed. So earlier it used to be 20 lakhs above High Court. Now it is that 20 lakhs has been changed to 2 CR, and that so this is pecuniary jurisdiction of the trial court is now up till 2 CR. Up till 2 CR. So beyond 2 CR you go to High Court. So just keep in mind, and then you one more term which will be referred in this in section 7, second line, you will see ordinary original civil jurisdiction. Now, ordinary original is the first court where you will file your suit. Now, if you have let's say if you have a claim of 10 CR, so the ordinary original civil jurisdiction for this suit would be High Court. In common parlance, कि आप suit पहली बारी कौन से कोर्ट में फाइल करोगे? You obviously you would not file your suit for the first time in the appellate court, right? Let's say आपका, now you take another example for the original civil jurisdiction. Your suit subject matter, as I will refer to that case law, is my pecuniary jurisdiction was up till under 2 CR. So I filed my commercial suit subject to, because that commercial dispute definition I satisfied in a copyright matter, and I filed the suit before the Saket District Court. So I will have to decide कि मेरा pecuniary jurisdiction कितना बनता है. Based on that, I will decide the place of filing the suit. So this is very important. So these are very fundamental provisions. So ordinary original civil jurisdiction is, which is the first court where you will file your suit. First court is important because first court में file करोगे, then you will undergo the stages of the appeal and everything. You can't file a original suit in the Supreme Court, right? So the original, let's say आपका suit matter is 2 lakhs. So you file as per the pecuniary jurisdiction given in the schedule. You file that 2 lakh rupees before a civil judge. I'm not talking about the commercial thing, but I'm just saying on the ordinary civil suit, 2 lakh rupees है तो आप civil judge में जाएंगे, which is the first original civil jurisdiction for that particular 2 lakh rupees suit. So this is how you compute. So you should know, कि आपका client recovery कितने पैसे की मांग रहा है, क्या documents हैं, it comes back to the same thing again and again. You have to know everything in advance. So 6 says the commercial court shall have jurisdiction to try all suits and application relating to commercial dispute of specified value arising out of the entire territory of the state over which it has vested territorial. Now you have vested, which has been vested territorial jurisdiction. It means आपका 50 crore का suit है, commercial suit है, you can't file in Delhi because the let's say the subject matter of the suit is a property which is situated in Ghaziabad. or in Bombay. So territorial is where you will file, where the subject matter or the property of that suit is situated. So this is important. So next you see explanation: for the purposes of this section, a commercial dispute shall be considered to arise out of the entire territory of the state over which a commercial court has been vested, if the suit or application, if the suit or application relating to such commercial dispute has been instituted as per the provisions of so and so. So 16 to 20 basically talks about the cause of action. Cause of action in a civil suit. So cause of action say you will decide where to file a suit, right? So you can just separately read that provision. Section 7, all suits and applications relating to commercial disputes of a specified value filed in the High Court having ordinary original civil jurisdiction shall be heard and disposed of by the commercial division of the High Court. Commercial division means single judge of the High Court, and ordinary original civil means you have the original jurisdiction of a suit which is beyond 2 CR. Right? So you have original suit jurisdiction either in the trial court or in the High Court. So you have to decide where. Of course, subject to satisfaction of the commercial dispute, and only upon which you will file under the commercial category, as in that case study I will refer, copyright. Next, provided that all suits and application relating to commercial disputes stipulated by an act to lie in a court not inferior to district court and filed or pending on the original side of the High Court shall be heard and disposed by the commercial division of the High Court. It basically says by the process of elimination. It says all suit and applications stipulated by an act not inferior to district court, right? So you remove the trial court aspect and filed pending on the original side in the High Court, is already pending in the High Court, shall be heard and it will lie before the High Court, right? Provided further, second provision provides further that all suits and applications transferred to the High Court by virtue of subsection 4, section 22 of the Designs Act or 104 of the Patents Act shall be heard and disposed of by the commercial division of the High Court. This provision says it has been specifically said for these two provisions, the matter will go to the High Court, so obviously it will go to High Court. Now you come to section 8. Section 8 basically deals with, section 7 basically deals with the aspect of the jurisdiction, where you file it. 8 says it bars remedy of revision and any interlocutory application. Interlocutory application is basically which doesn't decide any right, it's a miscellaneous application. And revision, revision and appeal, again there's a distinction. Revision is against an order which is substantive in nature, which affects rights of any party. And appeal lies against the final judgment. So this clarification is important because you should not confuse between revision and appeal. Revision is in a pending suit, any order you challenge before the appellate court, but that order has not to be interlocutory. It has to affect some rights. So you need to understand the matter, then only you will be able to understand ki wo affect right ho rahe ya nahi ho rahe. So it says notwithstanding, so just keep in mind the distinction between revision, interlocutory application and appeal. Notwithstanding anything contained in any of the law for time being enforced, that which means it has an overriding effect of all other provisions and all other acts, notwithstanding, non-obstante clause. No civil division application petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction and any such challenge subject to provisions of section 13. Section 13 is the appeal provision. As I said you that 4 courts mein kaun si appeal kahan pe jati hai, shall be raised only in an appeal against a decree of a commercial court. Decree is basically judgment, though they are not same. Decree is the terms on which a judgment is passed. Judgment is the reasoning of the judge. Decree is to be executed in an execution petition after the judgment. So you may see section 2 of the CPC decree is different. Let's say the judgment says 15 lakh rupees at the rate of 15% from the interest is penalized and for future plus cost. So whatever the terms are there, that constitutes a decree. And when a decree is prepared after the judgment, that is called decree sheet. So after decree sheet, you have to execute that decree in the execution proceedings. That is Order 21 CPC read with Section 47 CPC. So that is the further proceeding. And as time and again said that it's said and done simple that you obtain a judgment. Actual agony of a plaintiff starts to after the judgment is passed in the execution proceedings, because you have to then execute, call the plaintiff, defendant. Let's say in a matter defendant is not turning up, so you call the defendant to court. He doesn't come up. Then issue warrant. Then issue warrants of possession. Then the bailiff is appointed. Whatnot. So it's a very, and which is why Order 21 CPC, being the complexity of the execution process in India under CPC, is the longest provision in it has the largest number of rules. Rule 105, 105 rules in Order 21, which is the maximum in any order of the CPC. So the scheme of CPC is section correlate to orders, and order contains rules. So I think 1 to 156, 157 sections are there in the CPC is subject to correction, and every section correlates to an order. An order contains your rules. So that is how the functioning of the CPC. So just to be clear, CPC is a procedural law. Your IPC is a substantive law. Substantive is which determines rights and liabilities of punishment. Which is the law which regulates a procedure is called procedural law, CRPC, CPC. So your certain acts are both procedural and substantive. Evidence Act is a unique act. So it contains both. Primarily, it contains the procedure, how the trial is run, but there are certain provisions also which are substantive. So it's very important. So thereafter, Section 9 is transfer. It's not very relevant. You can have a read of it. It basically says that pursuant to the coming of Commercial Courts Act and the change of the jurisdiction from 2 CR to from 20 lakhs to 2 CR, what is the what happens? How the transfer takes place. I'll just read through briefly. Notwithstanding Section 9, notwithstanding CPC, in the event that a counterclaim filed in a suit before a civil court relating to a commercial dispute is of specific value, such suit shall be transferred by the civil court to the commercial division or commercial court, as the case may be, having territorial. So a simplicity case of transfer. 2, in the event of such suit is not transferred in the manner contemplated under subsection 1, commercial appellate division, which is the division bench. Appellate division of High Court means division bench of the High Court exercising supervisory jurisdiction over the civil court in question may, on an application of any of the parties to such, withdraw such suit pending before the civil court and transfer the same for trial or disposal of so and so, as the case may be, having territorial. 2 says basically if you file a suit before the wrong court, and the High Court says, High Court calls up the record from the trial court and says, I think there's some error in this. So it says under supervisory jurisdiction, on the application of any party makes an application for transfer, withdraw that suit from the trial court, and call it before itself, means High Court. So it's a case of transfer. Section 10 is important. Jurisdiction in respect of arbitration matter. Now, just to give you a heads up, Section 8 along with Section 5, 6 of the Arbitration Act says, in a civil dispute, if there's an arbitration clause, and it says arbitration has the exclusive jurisdiction over that dispute and all connecting matters, then the matter will be referred to an arbitrator. Then the matter will be tried under Arbitration Act. Even though it's a civil suit pending, the defendant says, files an application before the court and tells court that, look, there's an arbitration clause, and this civil suit is pending, even though this suit should be stopped, and the proceedings should take place under the Arbitration Act in terms of that particular clause which says all dispute defer to arbitration, including their enforcement and the interpretation. So that thing. So the matter then will go to arbitration. Section 10, where the subject matter of an arbitration is a commercial dispute. Again, you have to satisfy it. It falls within section 2(1)(c), which is commercial. I will just come back to A1. If such arbitration is an international commercial, in case of international commercial arbitration, all application or appeals arising of such arbitration under provisions of Arbitration Act that have been filed in the High Court shall be heard and disposed by commercial division. So international commercial arbitration matters will be heard by commercial division, DB bench of High Court, provided it satisfies commercial dispute 2(1)(c) section. Next, if such arbitration is other than international commercial arbitration, all application appeal. So this deals with arbitration other than international commercial arbitration. Application appeals arising out of such arbitration under the provisions of Act that have been filed on the original side. Now, you may note I explained the original. Original means कि आप पहला your first court of first instance for that subject matter. अगर 10 crore का matter है, the original side would be High Court. Minus the fact that it is not an international commercial arbitration, that it will fall under clause 2. It says if such an arbitration is other than international commercial arbitration, all appeal applications so and so that have been filed on the original side, which means more than 2 CR of the High Court shall be heard and disposed of by the commercial division. Commercial division is your appellate single judge High Court, where such. So the international commercial was just to recollect clause 1 commercial. I stand corrected. Commercial division is a single judge again. Yeah. So clause 2. So 1 is international commercial arbitration on the original side. 2. Just scroll down mine for the clause 2. Yeah. Clause 2 is matters of arbitration other than international. Again, it will go to High Court. Third, if such arbitration is other than an international commercial arbitration, so it is not an international commercial arbitration, all application appeal arising out of such arbitration under Arbitration Act that would ordinarily lie. Ordinarily lie means original jurisdiction suit ki kaun si hai, which is ordinarily lie before any principal civil court of original jurisdiction. Original means notwithstanding the Commercial Act, original for the civil judges, which is the first court civil judge, senior civil judge, ADJ, district judge. So we are concerned with clause 3, district judge. So the original ordinary would be for a civil judge 2 lakhs, just hypothetically. Senior civil judge 10 lakhs, and more than and under 2 CR would be ADJ or DJ, depending upon other factors. So in this background, now you read, if such arbitration, clause 3, if such arbitration is other than international commercial arbitration, all application appeal arising out of so-and-so would ordinarily lie before any principal civil court of original jurisdiction in a district, not being High Court. So it is clarified by negative language that clause 3 will not be applicable to High Court, meaning thereby suit will not be filed before the High Court. It will have to be in the district court. Shall be filed in, heard and disposed of by commercial court. Commercial, as I said, you recall, commercial court, commercial appellate court. Then the third court was, I recollect, commercial division, High Court, commercial appellate division, division bench of High Court. So it says commercial court, which is the ADJ court, exercising territorial jurisdiction. Territorial means, let's say you file a commercial suit before ADJ, or just forget about you before you file before the district court concerned. Property lies in Saket, so you file commercial court under 2 CR, property lying in Saket before Saket district, and vice versa for all the other district courts. Property situated Rohini, you file before under 2 CR, plus commercial dispute definition satisfied, you file before Rohini commercial code, all district courts have commercial divisions, commercial courts in the trial court. So this is how. So clause 1 says High Court, clause 2 says High Court, clause 3 says High Court, trial court. So you need to just conceptualize the interpretation along with the subject matter, which is why I gave a brief background about the pecuniary, about the territorial, about the original, ordinary, and so on. 11 says, notwithstanding anything, a commercial court or commercial division shall not entertain or decide in appeal, suit, application, so and so. It basically says where the jurisdiction of a commercial court is either in two factors, either expressly, last line, just highlight this section 11. If the jurisdiction of a commercial court is either expressly or impliedly. Expressly means provision में लिखा हुआ है under a particular act इस act के कोई भी case commercial suit में नहीं जाएगा. This is express language. Impliedly also, by implication, by necessary interpretation. So these are the two hindrances to filing a suit or case in a commercial court. So section 11 deals with the bar to jurisdiction. Section 12 is specified value. Specified value is basically now you determine the pecuniary value of a suit, of a property. Let's say आपकी property 5 crore की है. So 5 crore is called the specified value of subject matter. Subject matter is what? Property, immovable property, movable property. आपकी 5 CR की you have an expensive car. उस पे dispute चल रहा है. So that is the subject matter. That is a movable car. And 5 CR is the specified value. So how do you determine specified value is given in A to E, where the relief is sought. So A to E deals with particular topic, particular subject matter, movable, immovable, particular contract. A, where the relief sought in suit application is for recovery money. So recovery money mein, how do you determine your quantum of the pecuniary value? The money sought to be recovered in the suit application inclusive of interest. Interest मिला के बोल सकते हो. Let's say आपकी recovery 20 साल पुरानी है, 15 लाख रुपए, and interest उस पे add हो रहा है, and you want to, and your 15 lakh plus interest मिला के 2 CR से ऊपर आ गया. So your specified value is more than 2 CR. So you file High Court. So you need to understand your matter very deeply and threadbare. Where the relief sought in the suit for application for recovery money, the money sought to be recovered inclusive of interest computed up to the date of filing the suit, as the case may be, shall be taken into account for determining specified value. So basically, this is the determining factor कि आप कौन से कोड में फाइल करोगे. Let's say आपका the example I gave 15 lakh rupees and the interest is compounding interest and it became due from 1990. तो वो compounding 15 लाख का 2 crore रुपए हो गए. So more than 2 CR, High Court, under 2 CR, trial court. So the categories in recovery matters mein you refer to 12(1)(a). Now you come to B, where the relief sought in the suit application, appeal application. So there are 3 categories: relief sought, suit, appeal, application. It applies to all 3. Relates to movable property. I gave the example of car. उसकी market value कितनी है? You have a Bentley, vintage car, that movable property. Market value उसकी 15 CR. So, and you want to file a commercial suit on that. You gave a car to some exhibition person. Those vintage royal, vintage rallies, it happens. And you gave your vintage car to somebody, and he promised to pay you 10 CR for that event. And your car would be showcased in that, polo events and, so and so. So there's a commercial dispute because the activity, that event was a commercial event, commercial dispute. Movable property, car, market value 10 CR, recovery 10 CR, more than 2 CR, High Court. So that is how you see where the relief sought in a suit appeal application relates to immovable property. You have a property in defense colony, market value 35 CR. You go to High Court. Immovable property is your defense colony property. Market value is you evaluate the market value as 35 CR as on the date of the suit, not 20 साल पुरानी. As the case may be, shall be taken into account for determining specified value. Specified value is your value of the subject matter of the suit. आप suit कहाँ file करोगे? What is the central, what is the object or the crux of the suit, right? So you have all different categories. A is recovery of money, B is movable, C is immovable, D where the relief sought in the suit appeal applications relates to any other intangible right. In intangible rights, you have you hold a patent in your favor. That patent is at valuation $1 billion. Or you have any actionable claim. Actionable claim is, I think, 130 of Transfer Property Act, subject to correction. So, invisible rights, right? So, you will file in this. So, how do you determine the valuation? Where the relief so and so, so and so, the market value of the said rights. So, the market value of the patent, market value of your actionable claim, as estimated by plaintiff, shall be taken into account. So, in the estimation of the plaintiff, you may not have a certified value or everything in the estimation of the plaintiff in public domain. So again, you have a new category of valuation, intangible right. E is where the counterclaim is raised in any suit, as I gave the example of counterclaim raised by defendant. Raised in a suit, the value of subject matter of the commercial dispute is such in such counterclaim as on the date of counterclaim shall be taken into account. I gave you the example of in a civil suit, defendant makes a counterclaim of 20 lakhs. 20 lakhs you will file before trial court. 2 CR or 2.5 CR you file before High Court. So you have 4-5 categories. Counterclaim E, D intangible right, C immovable, B movable, A recovery. So all you have different. So आप जब सूट ड्राफ्ट करोगे फाइल करोगे यू विल सी यार मेरा केस कौन सी कैटेगरी में आता है पहले मैं वहां देखूं एंड हाउ डू आई कैलकुलेट द वैल्यू देन यू पे कोर्ट फीस then accordingly you decide where to file the suit, then the entire process goes through. So all this has to be done prior. This is actually very very good order oblique judgment of a particular high court judge in Delhi. He says in most of the matters the actual application of mind of a lawyer starts after filing of suit, because he was actually adjudicating upon a WS or some belated application which was hopelessly time barred, and he made some comments there that particular parties filing application after application after application, knowing fully well that this exercise of thinking which application to file, what should have been done prior to suit and not after the suit. So it's a very particular, pertinent application. I generally refer this order against an opposite side who is, playing delay tactics, and of course, subject to facts, precise facts, and it's a very useful judgment because the entire exercise is very important for the reason that you have to do the entire exercise either on the civil side or on the criminal side. On the criminal side, you receive a brief for the person who has committed murder. You have to conceive his defense. You have to conceive and read the charge sheet, thorough, and pull out your own line of defense from those documents. Because remember, in a criminal case, you have to defend or do whatever from the basis of the documents which constitute the part of the charge sheet. So you can't go beyond charge sheet. So prosecution has pulled out their own version from the charge sheet. As a defense lawyer, you have to call out your own line of defense from that particular charge sheet. And then you will say that my version is more probable than the prosecution version. And since the onus is different in a criminal case, you have to create a doubt in the prosecution story, and that is it. And if and on the prosecution, the onus is stricter. The onus is they have to prove their case beyond all reasonable doubt. So they don't have to create a doubt. We have to create a doubt. So unless you conceive your defense, your story to defend that murderer in advance, before you file your first drafting that case, let's say bail application. Bail application, let's say, for example, the blunder I'm saying, it happens. You learn with experience. In a murder case, you receive a brief and your uh, your client says on X date I was in Bombay, murder happened in Delhi. So plea of alibi, Section 11 of the Evidence Act. Facts are not relevant, but they become relevant if they negate the fact in issue. That is Section 11 of the Evidence Act. In this language, you won't be able to call out that this is an example of plea of alibi. Sorry. Okay. Yeah. So the client says you and you blindly follow and you move an application. He's behind bars and you move an application. Say and you take a plea of alibi and you say he was in Bombay. And later on, you came to know he was in Delhi. So your version of plea of alibi has come on record. This is your defense version. This is your version. जिसके basis पे आप trial, you will conduct trial, and you can't have two versions because two version का मतलब होता है conviction. Because court will say कि वकील साहब आप तो खुद ही clear नहीं हो, आपका defense क्या है? So why I should believe you? Which means you are you are stating false in the court. So before you put your step for the first time in the court, you need to have your defense ready, either on the civil side or on the criminal side. As a defendant, you need to be very clear to make that counterclaim. As I gave you the example, counterclaim has to be very specific, document based. Which witness? How you will prove that? So these are very important things that you need to understand and conceive and plan, strategize in advance before you file a case in any forum. So coming back to after section 11, see the time. Okay, yeah. So thereafter, you come to section 12 is done. 12 is clause 2 and 3. Last two clauses were left. The aggregate value of the claim and counterclaim, if any, as set out in the statement of no, this is done. 3. No appeal or civil revision, or revision application under 115, which is the provision for the division under CPC, as the case may be, shall lie from an order of commercial court or so and so, finding that it has jurisdiction to hear a commercial dispute under this act. So, provision of appeal or revision on the ground of jurisdiction is barred. We come to clause 4. Section 13. Section 13 basically deals with appeals. Appeals, if you recall, I gave you the breakup from section 1 section. I gave you the 7-8. I gave you there are 4 courts: commercial court, commercial appellate court, commercial division, commercial appellate. Just keep that in mind. Violating section 13. Any person aggrieved by decision of commercial court or commercial division. So which means first and the third court. First ADJ and third is High Court in the sequence of a commercial division of a High Court, because it says very clearly, obviously it is High Court, may appeal to the commercial appellate division. May appeal to the division bench of High Court. Of that court means Delhi High Court within a period of 60 days. So this is clear now in terms of that that hierarchy which I gave you. Proviso that an appeal shall lie from such orders passed by the commercial division. Commercial division is High Court, single judge, or commercial court is the ADJ, that are specifically enumerated under order 43. 43 is appeal against orders, CPC, as amended by this act, and section 37 of the arbitration. Arbitration is appeal provision. So in these two particular categories, order 43 and 37, you go to particular court as mentioned in provision. Notwithstanding anything contained in any other law for time being in force or letters patent LPA. LPA is basically appeal within a particular court. Uh, LPA is basically intra-court appeal. Intra-court means within High Court appeal. A single judge say division bench. Notwithstanding anything contained in LPA, notwithstanding contained in any law in time and force 2 or LPA, notwithstanding any law or LPA, no appeal shall lie from an order or decree of commercial division bench of High Court, no appeal, or commercial court. Commercial court is ADK, other than in accordance with the provisions of this Act. So the provisions in these two aspects, LPA may say there is no appeal, and secondly, the commercial code otherwise than appeal provision has to be only in accordance with 13(2) and not beyond it. Expeditious disposal, 6 months. Section 14 says 6 months you have to dispose of the appeal. You can just go through it. Section 15, as similar to Section 10, if I remember correctly. Where was the transfer provision? Section 15 says transfer of pending suits. All suits and application, including application of arbitration and conciliation, are relating to a commercial dispute of a specified value, but pending in any civil suit, court, or in any district or area in respect to commercial has been constituted, should be transferred to the said commercial court. 15 is nothing technical. You can just run through, keeping in mind the above provisions. Is no application in mind. Is just simple. Thereafter, just scroll down there. 16 is basically amendments, the amendments which were made by Commercial Courts Act to CPC. It says provisions of CPC in their application to any suit in respect of commercial dispute of specified value stand amended in the manner as specified, right? 2, commercial division and commercial courts shall follow provisions of CPC as amended in clause so and so. So, it's again that the CPC provisions have been suitably amended in light with the Commercial Courts Act. Now you come straight away to 17 is again miscellaneous, nothing to explain. Now you come to section 21. No, I think it's the old one. Huh? It's the old one. I think you come to the rules. Okay. Anyways, but those are all, Section 21, just for the information, Section 21 says this act will have overriding effect. So, the Commercial Court Act will have precedence over other acts. Then, that's it. So 23 are up till 23 are the main provisions I've gone through substantively. Now you come to the central issue, Commercial Dispute Section 21C. Yeah, just come down a bit. Section 2, starting with Section 2. Just go upwards, yeah. Upwards. Yeah, Section 21C. Commercial dispute means a dispute arising out of ordinary transactions of merchant, banker, financier, and traders, such as those relating to mercantile document, including enforcement, so and so, interpretation, export, import. Third, issues relating to admiralty and maritime law. 4, transactions relating to aircraft, engines, aircraft equipment. 5, carriage of goods. 6, construction. And so these are very express subject matter which have been culled out. So you need to just scroll through while you file a suit. You see which category your case falls. in addition to the interpretation, I will just give you that from the judgments. 4 transaction relating to aircraft engine, aircraft equipment. 5 carriage of goods. 6 construction infrastructure contracts. 7 agreement related to immutable property. Now 7 is very important. It says agreement relating to immutable property used exclusively in trade or commerce. For example, you run a plot which is industrial plot, and a party is living there. So it will not be commercial dispute, even though that plot is an industrial plot and it may fall within the commercial definition. Now take one more example. An industrial plot given to a tenant for warehouse factory purpose. Now this will satisfy agreement related to immutable property, which is an industrial plot, used exclusively in trade and commerce. Industrial purpose के लिए वहाँ पे काम हो रहा है, warehouse के लिए दे रखा है. So that is a commercial activity. So word exclusively is very important. एक ही plot में, now take third example. In that same industrial plot, half, the landlord is staying, he's living. Half में he's let out on rent for that industrial activity. It will again not be a commercial dispute. So उसमें commercial dispute कैसे बनेगा? Landlord ने tenant को rent पे दे दिया. There's an agreement that you will use this plot for industrial activity. Now on the contrary, half plot में तो landlord खुद ही रह रहा है. And in the agreement, the word exclusively is not mentioned. And the tenant stop paying rent. The landlord as a plaintiff goes to the commercial court. He says, "My is a industrial plot, immutable property used in trade and commerce." Defendant says, "No, hang on. It is an immutable property, right? It is being used in trade and commerce, right? But see the agreement. It doesn't say exclusively used for trade commerce." And he takes pictures of the landlord sleeping in the house over the half portion and files along with the WS. And he takes an objection that, so the suit is filed, let's say, beyond 2 CR in the High Court. And in the High Court, he takes a preliminary objection that this suit is not maintainable in the High Court because it is not a commercial suit. High Court says how? Defendant says, look at the agreement. It doesn't say exclusively. And now see the pictures, landlord staying in that property. Therefore, it is not also exclusively. So defendant has shown both the actual ground reality and the agreement. So therefore, that is not a exclusively trade and commerce. So this is very important. So on these aspects, you need to read the judgment very properly. That interpretation will come from there. You may not know on a bare reading that exclusively ka itna important meaning hai. But that is how you go. 8 franchise agreements. Franchise is IPL agreements. Franchisee आपने किसी को दे दिया, you have a property, let's say McDonald's, उसमें कोई dispute हो गया. McDonald's is not paying rent to you, so you go to commercial. 9 distribution license agreement. License agreements में management and consultancy. Consultancy, you give again your property to some consultancy for the HR, everything. Joint venture, JV agreements, shareholders agreement. You buy some, there's a shareholders agreement in a company consisting of the shareholders. That is a commercial dispute. Subscription and investment agreements. You subscribe to certain shares of a particular company, you buy them, or you make some investment in a company, and there's a dispute in that investment agreement, commercial dispute. Let's say I have a client, he invests 3 CR in a IPL company. He's a joint holder. उसमें कोई dispute आ गया है, commercial dispute, more than 2 CR High Court, under 2 CR Trial Court. mercantile agency, you run some agency, you took some agency of a car dealership or some gas pipeline, agency agreement, partnership, technology development agreement. You open a startup for technology development, or you hire some technology company to develop some technology for you. There is a technology development agreement. Intellectual property rights, those obviously should come in commercial. Just scroll down. 18. Agreement for sale of goods or provision of services. Sale of goods. 19. Exploitation of oil, gas. These are, these you can understand, no interpretation. Insurance, reinsurance, contracts of agency under Contract Act, I think Section 202. Now this is important, residuary, 22. Such other commercial disputes as may be notified by central government. But such other commercial dispute has to be in line with the above categories. Any combination, any singular or whatever. But it has to satisfy commercial dispute. Now this is the negative provision. Explanation: a commercial dispute shall not cease to be a commercial dispute merely because it also involves action for recovery of immovable property or for realization of money out of immovable property given as security, or merely because subject matter is A, it will not cease to be a commercial dispute. It has to be something more than that. B, one of the contracting party is a state. If a contract is between one private and state, doesn't matter, it will still be a commercial dispute. Merely because state is a party will not take it out of the commercial dispute. D. So this is, so I'll just just quickly run through the two case laws. Just open the case law on the commercial dispute of Delhi High Court. Yeah, I'll just run through. Qatar Airways versus Airport Authority of India. I will just today I will in next 10 minutes I will refer to this case law and briefly in just 5 minutes the case study, and then I would want to have last 25 minutes for the queries and questions, right? Because you may have some queries. This case says it is an order. It says the defendant by this application state that the plaintiff has wrongly labeled the suit as a commercial. Now this is that interpretation which you need to understand. The counsel for plaintiff appears on notice and considering the nature of the application he does not want to file reply. 4. Suit is for recovery of $US so and so as damages for loss suffered by the plaintiff on account of damage to the aircraft. I'm reading para 4. It says loss suffered by the plaintiff on account of damage to the aircraft of the plaintiff at Calicut International Airport, which is lot according to plaintiff is attributed to defendant. So therefore, there is a disputed fact. Counsel for plaintiff on inquiry states that claim of the plaintiff in rupees is 4.5. Therefore, is filed in the High Court. It is a contention of the counsel for defendant. The plaintiff has titled the suit as commercial division when the same is not applicable. So it is a case where a defendant says, "Ye to commercial suit hai nahi," because in turn means it is not a commercial dispute between under Section 2(1)(c) as we run through. Section 2(1)(4) says constitute arising out of transaction relating to aircraft so and so as commercial dispute. 8. Counsel for defendant is correct in his contention that a claim for damage caused to the aircraft would not fall within clause 4. 9. Counsel for the plaintiff has stated the plaintiff in the replication, as I said you, the stages of the case. Replication is reply to WS. Has pleaded that though the suit as originally filed was by the airline, but the airline has recovered insurance. The insurer is now pursuing the suit. He thus states the suit would also fall in clause 20. Now clause 20 says insurance and reinsurance, as we just referred. Two terms: insurance contracts, insurance agreements, and reinsurance. However, there is no amendment in the plain till date, and this court to determine the nature of the suit is only to see the averments in the plaint and not the replication. to which the defendant have not had any opportunity to respond. Now, the reason why I said to you at the beginning was you draft your plaint very carefully, because now what the court is saying. I will see your plaint and nothing beyond plaint. So if you not properly drafted the plaint, and if you have haphazardly drafted the plaint and it doesn't contain complete facts, then you're out. Now see what he says. Counsel for the plaintiff has then relied upon the judgment of division bench of the Gujarat High Court so and so, opining of the objects and purpose of the Commercial Courts Act, which means principally Section 2(1)(c). Have at well, I have, however, in Sanjeev Kumar, this court's own judgment, held that all suits that in common parlance may be stated to be commercial cannot be brought within the ambit of Commercial Act, and that if the same is done, the doors of Commercial Courts Act would be to open wide open. Purpose of enactment as the specialized courts would be defeated with such courts being so and so making expeditious disposal. So the purpose was commercial suits jaldi chalne chahiye. They should be expeditious because ordinary suits बहुत slow chalte hain, subject to exceptions. So they want to fast track the commercial disputes because the foreign investors, general public to the world should go that इंडिया के जो कमर्शियल डिस्प्यूट्स हैं, अगर कोई डिस्प्यूट हो जाए तो 20 साल नहीं चलेगा, फटाफट that would be done. So that was the policy objective. So that is very important again. Attention of the counsel for the plaintiff has been drawn to the judgment of division bench so and so held that suit for cancellation of a power of attorney, even if with respect to an immovable property used exclusively in trade or commerce and as part of transaction, para 13, as part of transaction of such property would not constitute a commercial dispute within the meaning of so and so. The counsel for plaintiff has then drawn attention to the judgment of single judge of Madhya Pradesh High Court, where the words business transactions have been interpreted. The legislature in the commercial courts have not defined commercial dispute as disputes arising out of all commercial transactions. Instead, legislature has opted to specify 22 transactions, which is from subclause to subclause last. Disputes arising wherefrom will constitute a commercial dispute. That being the position, every dispute arising from commercial transaction without same falling in under any of those categories within the meaning of Commercial Courts Act will not suffice. Application is thus allowed, meaning thereby the suit filed did not satisfy the commercial dispute definition under those 22 categories under Section 2(1)(c). Now just come to the second case. This again, I think, of Justice Enlow. Yes. He's worked, Justice Enlow now he's retired, but he was one of the, he dealt extensively on the commercial side. And mostly you will have, notice these are all oral. He just dictates he used to dictate in the court itself, which means that the entire facts were in his mind, and he was so well read, so thorough. The applicant seeks return of plaint in this suit for recovery so and so as a commercial suit, contending that it is not a commercial dispute. Claim of the plaintiff for money in the present suit is on the basis of 3 defendants having sold immovable property. So just a caution. If you see Section 12, I had gone through the category of the commercial dispute of various various category, merely because it falls under a recovery, merely it falls under movable, merely it falls under immovable, and so on, will not constitute the subject matter into a commercial dispute, provided it falls under any of the 22 categories, Section 2(1)(c). This is what the court is trying to refer in the judgment. Just go back to the judgment, man. It says claim of the plaintiff for money in the recovery, because what used to happen earlier was mainly because recovery money, mainly because movable property, without appreciating the actual definition of commercial dispute, court started raising this objection because you are filing a suit in the wrong court. So it says para 2, claim of the plaintiff for money in the Present suit is on the basis of the three defendant having sold immovable property to the defendant, uh, immovable property to the plaintiffs with a promise to deliver the title of documents, and a plaintiff subsequently realizing that title documents were lying deposited by way of equitable mortgage with the State Bank of Patiala, and for release whereof the plaintiffs had to deposit monies before the DRT, and which monies are not sought to be recovered from the defendant. Suit has been labeled as commercial dispute. Para 3, pleadings mean plaint, that property purchase has always been used by the plaintiff for commercial purpose, right? Next, it is 4. It is not in dispute that minimum pecuniary jurisdiction of this court to entertain original suits. If you recall, original means the first court with Delhi Amendment, so, with 2 CR. As I said you earlier, it was 2 CR, then it was beyond 2 CR, High Court. And unless this suit qualifies as a commercial dispute within the meaning of so and so, the suit having instituted thereafter will be below the minimum pecuniary jurisdiction and of this court, and plaint will have to be returned to the filed in the court of appropriate pecuniary. Pecuniary means value. कितने पैसे की का सूट है वो. The only question for adjudication, para 5, is thus whether claim of the in the suit is a commercial within 21C. 6. 21C contain clauses, clause 1 to 22, list the transaction dispute arising out of which qualify with respect to commercial dispute. Section 7, read with 2.1, if the valuation of the subject matter is less than 1 CR, this court as commercial would have jurisdiction. Counsel for plaintiff relies upon clause 7, as per which a dispute arising out of agreement so and so exclusively in trade is a commercial dispute. The counsel for plaintiff argues that dispute subject matter arises out of agreement of sale and has been used exclusively. Just scroll down in trade commerce. He thus contends the commercial division of this court has the jurisdiction to decide the suit, and the plaintiff is not liable to be returned. Plaint is liable to be returned means return जब होता है आपका plaint when it is filed before a wrong court. Okay. Para 8, counsel for the plaintiff on being asked as to show that the immovable property sold by the defendant is used exclusively as I referred to you. Now he is focusing on आप मुझे ये दिखाओ plaint में plaintiff को बोल रहे हैं court कि वो exclusively used हो रहा था, has drawn attention to the site plan annexed to the sale. Now he's referring to documents along with the plaint. And next has drawn to the attention to the site plan annexed to the sale deeds, and to contend the same does not contain any toilet or kitchen and is construed like a shop. I've drawn the attention of counsel for plaintiff to my judgment. He's referring his own judgment, where I have held that an immovable property, if illegally used exclusively for trade commerce, cannot qualify under so and so. And it has been shown that immovable property is legally permitted and to be used exclusively for plaintiff, though in the plaint have pleaded. So now this, the quality of this Justice Enloe was, he was very strong while now he's retired. He used to focus on the foundation pleadings. Pleadings mein you focus, you show for pleadings. If you don't show, you're out. Because law says you can't go beyond your pleadings. If you haven't stated a fact in the pleading, then you're out. So that is the importance of drafting a comprehensive pleading. He says now, just see, he will just dismiss the suit, this order, this application, whatever it is, on the basis of the pleadings only. The plaintiffs, though in the plaint have pleaded that property was purchased by plaintiff for commercial purposes and plaintiffs are conducting the closed business from the property, and property has always been used for commercial, and plaintiffs are continuing to use the same for commercial, but has not filed any document to show that the use was permitted by law. So he basically is using for illegal purpose, and which as per his own judgment, as referred above, does not qualify for commercial. If the use is illegal, then you don't qualify for commercial use, but has not filed any document to show that the use permitted by law of the property is for trade or commerce, that property is situated in a zone locality wherein are permitted to be used exclusively for trade or commerce. The counsel for plaintiff next draws attention so and so. One shop, then he shows one shop and back shop portion of. He's basically referring to site plan to show कि मेरी जो shop है वो commercial में आ रही है. Just scroll down. 11. However, therefrom, it also cannot be said that with certainty that property is legally permitted to be used exclusively for trade commerce. Then you go to para 12. Needless to state, the concept for defendant contains that property is not permitted to be used exclusively for trade. So exclusively for focus ho raha hai. If it is not exclusive, you're out. Version para 13, version of the counsel for plaintiff for defendant 1 is also supported by a recital of the sale deed of other portion which do not describe property portions sold there as a shop. Counsel 14. Counsel for plaintiff says contains that it is a matter of trial whether plaintiff's property is exclusively trade or not, and since plaintiff is averring that the shop is so used, no case for returning the plaint to the correct court is made out. I am unable to agree with this one. So once a plaintiff seeks to bring a suit which otherwise is not below, which otherwise is below the minimum of this court, which is the High Court, means below 2 CR, to this court claiming the suit to be arising, it is arising out of commercial dispute. It is bounden duty plaintiff to establish so in the plaint. If it is not so, if the question whether so and so, just go down. Just come to the finding now. Solved only. Last three paras. Just go upwards a bit. Down. The para 28. The counsel for the plaintiff draws attention to para 15 of the judgment, where the division bench of this court did not go into the question whether property subject matter before the division bench was exclusively used trade or not, being of the view that the nature of the dispute raised in the suit did not concern any agreement related to property. I am, however, unable to see as to how the same helps the plaintiff. The present is also a case of sale deeds of property executed by defendant in favor of plaintiff and cancellation whereof the defendant is seeking in the suit which has already been transferred to the subordinate court and for compensation for misrepresentation, so and so, so and so. On the same parity of reasoning as given by division bench, the plaint in this suit would also not qualify as a commercial dispute. Therefore, hold dispute subject matter be not a commercial dispute within the meaning of section 2. So basically, court said कि आप मुझे plaint से दिखाओ, अपने pleading से दिखाओ how you satisfy the clause exclusively used for trade and commerce. So just see the importance of pleadings. Technical objection पे ही plaintiff का जो objection dismissed, suit returned to the concerned court because under 2 CR, therefore you go to trial court, not high court. I think I can stop here today, and I think the queries now can be taken because, and thereafter tomorrow I will come to the case law case study to give a practical perspective of what we have discussed today in detail.
Thank you, sir, for your enlightening session. We have one question in the chat box by Azam Khan. So he asked that he's a first-year student and he wants to know the qualities or skills that he needs to work on from now onwards to excel in drafting and pleading, and especially for newcomers and how they can overcome the fear of presenting themselves in open court.
First of all, most importantly, in my view, with limited understanding, start reading a trial court judgment a week. Trial court judgment means trial court judgment and not high court judgment. Why I'm saying so? Because trial court judgment will contain the plaint, documents, evidence, how the evidence is appreciated in detail. What is exhibit number? What is mark? So those documents, those plaint, those evidence, arguments, contentions, observations would be dealt with in detail because trial court is a court of record. These findings, observations are crystallized, summarized in the High Court. You won't be able to appreciate in the High Court judgments unless you read the trial court judgments. So the trial court judgments are very important. Only from this perspective, you'll understand how you draft a plaint, what you should do, what not you should do, what point you should put in the plaint, what point you should not put in the plaint. So that is very important. So this is, you will, in my, I read Indian Kanun judgments a lot. I read trial court judgments a lot. So that gives you the appreciation of the evidence. How do you appreciate an evidence? How do you appreciate a plaint? अब जैसे the judgment of Justice Enlaw. He started from the trial court. Then he shifted to High Court. Then he became senior counsel. Then he became a High Court judge. So he's seen all through. Now you see the clarity in the judgment. He's not even adjourning the judgment. He says he's asking the queries on the spot, which means he knows everything. He's asking the negative points from the counsel, which he's not able to answer. And therefore he says, the counsel for the plaintiff is not able to answer my queries. The counsel for plaintiff is not able to show from the plaint. The counsel for the plaintiff is not able to show from the document as to how that dispute falls within commercial dispute. See, you may understand the provision, but to understand the provision in a thread-made manner, understand the categories, understand the interpretation of the word, as I said you, exclusively. You may know the section, but not many of you may have noted or may have observed the 22 number categories, unless he referred in the judgment. I may have referred the provision, but I did not focus on 22 categories are there. He summarized that. So once you go through that deeply, and you know that ठीक है, मैंने interpretation समझ लिया, मैंने judgment पढ़ लिया है. I know now everything from one category to 22. So tomorrow when a suit comes to you, a client comes to you, you will immediately know कि कौन सी category में fall करता है. What is the interpretation? Then you will ask the client the precisely same queries which the court ask to the client कि आप बोलते रहे हो कि आपका use है, पर आपका illegal use है. So as a lawyer, you have to be well read, and not take everything on face value from the client, because client will mislead you. So you have to, tell the client that you have to tell me everything upfront. Then only we will, find some solution. If let's say in this example only, client comes to you and he says, "Meri factory hai," and therefore we file a commercial suit. But as a lawyer, you know the interpretation, and you also ask him, "आपकी factory कौन से area में fall करती है?" In a residential locality, let's say defense colony. And the next question you say and you ask the client is, आपकी property तो commercial dispute का मतलब तो आ रहा है, but defense colony में industrial activity is not permitted. So you are doing an illegal work. So illegal work and purpose will not fall within commercial dispute. So hence I cannot follow. Hence, as a lawyer for the client, I cannot file a commercial dispute. And if you file that suit, then a Justice Enlaw will come into picture. So I think the foremost is you read trial court judgments. Start with one judgment a week, and then you will understand and you will yourself see your appreciation of the evidence will get better. So that is the answer.
Thank you, sir. If you have any questions, then you can also raise your hand and unmute yourselves and ask the question, or type in the chat box, whatever works.
I think queries may not come today. I think queries may come tomorrow, because it was slightly on the deeper side. So I think if they can go through the Bare Act on their own today, apply their mind, then the queries will come.
Right, sir. Right. We have one question from
Yes.
how clients who bring commercial disputes are different from the normal clients, and how should we build trust with the clients having commercial matters, since they have very high stakes?
See, the answer is the commercial client will be a well-read client. He must be knowing a lot more than you. So first, if the client comes to you very suddenly, then you take some time and say that, we have some confidence after a few days, and you brush up everything possible you can. and at least have the basics ready. And secondly, you should not you only state the correct facts to the client. Don't try to make up facts which you don't know, because he's a world wisely person. He runs a commercial entity, whatever. So you advise honestly, and you, for example, in this example which I gave you, a rich person, a big client who runs a factory in defense colony, and he says, uh, Mr. Consul, please file a commercial suit. I think you advise him correctly, because wrong advice will not take you further. Even if you file a suit on his pressing insistence, you file a commercial suit in the high court, the result would be justice and law judgment, and you will only embarrass yourself. You advise him correctly, let him go to some other lawyer, let him uh, let that suit get dismissed, and then he will come back to you, I think. Because by advising wrongly, I don't think so you are doing any purpose. It will only create a bad impression. So you advise honestly, correctly, and make sure when you sit with the client, you know at least more than basics, and read the present judgments, ongoing judgments on the commercial, which is the latest legal position on the commercial aspect. That you should know, because that is very important. Because that is the roadmap where you should lead to him. You can always say that this is the latest case law on this point, and held by so and so court. So your understanding is better, then only you will be able to deliver with confidence before that client. Because make no mistake, that client has come to you. You take it for granted. He's come to you after being advised by few lawyers. So he will cross check you. So if you advise wrongly, just for short sightedness, for whatever reason, you will not do any good to yourself, being a young lawyer.
Thank you, sir. We have one question from Azam. What types of judgment would you recommend for newbies?
Civil. Criminal you can read, but on the civil side it is important, because you have interplay of various acts. Like in a commercial dispute, you will have Registration Act interplay, you have CPC, you have limitation, you have Court Fees Act, you have Specific Relief Act, you have Partnership, Sales of Goods Act, Transfer Property Act. So the interplay is very important for your understanding and your appreciation. On the criminal side, you can read, uh, but on the criminal side, is basically you have to understand the defense of the prosecution and defense of the accused. You have to pull that line, and then only you will be able to understand that which line cross examination is going in what direction. So, more important, if you ask me, would be civil. Criminal, you can also read side by side. And
Thank you,
focus,
sir.
and focus when you read any bear act, focus on the policy objective. Go behind the act. Go read around the act. Why that act was introduced? What is the meaning? If you understand that meaning, then you would be in a better position to correlate with the provisions. That why, see, you read a provision. There's there's one reason you understand. There's another reason why it came into picture. If you understand the provision, why the provision came into picture, you will understand better in the interpretation. For example, that word exclusivity, that 21C clause 7, exclusively used exclusively for trade and commerce, trade or commerce. Exclusively word is important because the purpose of the act is to focus on the commercial disputes exclusively. So if in a particular property, or if in a particular dispute, the subject matter is mixed up, it is a commercial dispute also, and it is some other dispute also. So, that level of exclusivity is very important. So hence that interpretation that show me from the plain, show me from the document, how it is exclusively a commercial dispute between 21C, clause 1 to clause 22. So you need to go behind the words. That is very important. It's not about simpliciter reading a bill act. It is going behind the policy. Then only you will have better interpretation as compared to other people who just have a bare reading.
Thank you, sir. We have a question from Jasraj. He's asking that with your prior permission, can he ask a question related to CPC but not related to the topic at hand?
Yeah, please.
Jasraj, would you like to unmute yourself or maybe type in the question?
Yes, good afternoon, sir.
Yes, please.
So my question is under Order 41, Rule 23 of the CPC, which says that remand of a case by an appellate court. So, sir, with
Order 41,
this
Rule
order,
27.
Rule 23, yes, sir.
23.
So it says remand of a case by appellate court. So basically, in this order, the appellate court decides the issues and what all the case should be about and remands it back to the trial court for final adjudication.
Yes.
So will this order be considered as an interlocutory order or a final order, sir?
Which order? This remand back?
Order 41, Rule 23, remand of case by the appellate court.
This remand order, you are asking whether it will be an interlocutory order or not?
Or not? Yes, sir. It will be interlocutory or a final order.
See, everybody just read the provision in the entirety because I want to understand what stage of the remand it will happen, because that is important.
I'll read the provision, sir.
Yeah.
Order 41, Rule 23, remand of case by appellate court.
At what stage?
Where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point and the decree is reversed in appeal, the appellate court may, if it thinks fit, by order remand the case and may further direct what issues shall be tried in the case so remanded.
So the answer is yes. I understood. So the answer is it is not an interlocutory.
It is not an interlocutory order.
Interlocutory order होता है जैसे यार आपने कोई जजमेंट एप्लीकेशन लगा दी, आपने कॉस्ट फेवर की एप्लीकेशन लगा दी, which affects in rights of either party. जहाँ पे rights और liability either accrues in favor or against. जहाँ पे rights.
But if sorry, sir.
Yeah. So
if it's considered as a final order, so if it's considered as a final order, then the trial court will decide the issue after the issue which is framed. But then it cannot go in appeal to the appellate court once again because it had decided finally. That was my question, sir.
Yes, on that particular point. See,
so after that, where will you go, sir?
Let's say, जो आपने मेरे को provision बताया, let's say in between a matter, court ने wrongly framed an issue. Just hypothetically, I'm saying wrongly framed an issue, and if you recall, I said in the beginning that issue has to be framed properly and with right onus.
Yes, sir.
OPP आना चाहिए, वहाँ पे OPP आना चाहिए. Now, ये जो आपका if you go to the High Court and you make this point that this is a substantial prejudice to me because you are basically reversing the onus. जो case plaintiff को prove करना है, you are putting on me, and which is wrong.
Yes, sir.
So High Court may say, or any appellate court, that I am remanding the matter with a direction to the trial court to reframe this issue if it is permissible in the facts of that of a particular case, and you reframe the issue and you put the onus properly, and the onus should have been OPP and not OPD. And with this grievance, the defendant went in the High Court. So this is the case of remand. So your second query was that on this point, appeal जाएगी, because this is sort of an appeal. Appeal जाएगी against final judgment. वो आप नहीं रोक सकते. You can't say that merely because the appellate court has remanded the matter, no appeal will lie. If I understood your query correctly. Appeal
thank you, sir.
Judgment. not in
Yes,
the
I got it.
remand. Remand is only on a particular point. Or let's say, I give you one more example. Plaintiff का suit ex parte हो गया, based on an address that defendant could not be traced on A1 Ashok Vihar address. An ex parte order हो गया है, and the defendant challenges that order before the appellate court, saying that same address and this ex parte is wrong. So वो remand back होके, he will have an opportunity before the trial court to appear, and that ex parte order, ex parte evidence or whatever that order will be set aside, and the case will proceed from there on onwards. So it is very fact situation and case specific, but remand back will be on a specific point, and you can't say कि remand back हो गया है and therefore there is no appeal. Appeal is always against the final judgment. Revision is there. Review is basically from the file before the same court. Let's say judgment में लिखा था 15 लाख रुपए और plaintiff ने खुद ही मांगे 14 lakhs. So that 5 and 4, so review you will file before the same court. Revision is against an order which is not interlocutory.
Okay.
During the pendency of this case, appeal is towards the culmination. Let's say on the criminal side, you file appeal under 374. Person की conviction हो गई. That is an appeal. Review is revision is आपकी bail तो नहीं बोलूंगा. आपके ऊपर चार्ज फ्रेम हो गए, subject to correction. So this is an interim order but substantive order because आपके ऊपर चार्ज फ्रेम हो गए गलत. How it affects your rights is अगर मैं डिस्चार्ज हो जाता तो केस खत्म हो जाता. So it affects your rights. So that is a test for the interlocutory. जो बीच में एप्लीकेशन होती है ना कि in a company matter, authorized representative of a company change हो गया, he's left the company, new heir will come, you move in application, IA. There's a so IA is basically interlocutory application, independency of a case. Order is concluding a particular proceeding on a date. So this is the difference.
Thank you so much,
Thank
sir.
you, sir. Thank you so much.
Thank you. So we have a question from Abhimanyu Singh. If an issue which should have been OPP gets categorized as OPD, will it not affect the plaintiff's case at stage of appeal?
Because it's a very important question. In the appeal, the appellate court would say why you were sleeping up till now, and what prejudice it has caused you, because you can't now conduct the entire trial again, because effectively you are asking me कि आप owners को reverse करो and you again conduct trial, because please remember owners के basis पे ही the parties lead their evidence. अगर डिफेंडेंट पे कोई ओनस है ही नहीं तो उसका काम सिर्फ इतना सा है कि प्लेंटिफ के वर्जन को वो अच्छे से क्रॉस एग्जामिनेशन कर दे विदाउट ब्रिंगिंग एनी डॉक्यूमेंट फ्रॉम हिज साइड. दैट इज ऑल. उसने अगर प्लेंटिफ के वर्जन को निगेट कर दिया, प्लेंटिफ वर्जन अपना प्रूव ही नहीं कर पाया, सो द नेट इफेक्ट वुड बी सूट डिसमिस्ड इन फेवर ऑफ डिफेंडेंट and not suit decreed in favor of plaintiff. So this is very important. Onus is actually very important. You have to be very vigilant. जब वो issue उस दिन फ्रेम हो रहा था और वो जज साहब उस दिन OPD कर रहे थे, So it's the only exception is you have to show before the court a substantial failure of justice. I'm actually doing a matter in which the similar thing happened. I would not name a matter, but um, I entered the brief in the appellate stage, in the Supreme Court stage, at the trial court level, and onus was put on me as compared to the plaintiff. And the entire thing changed. And then when I saw and asked the trial court lawyer as to why you didn't point out then he said, "Ab Supreme Court mein raise kar lo," which is you can't undo the entire 3 stages of case unless you show substantial failure of justice, which is who doesn't interfere. Or in any case, in any court, high court for that matter also, you have to show grave prejudice कि अगर वो नहीं होता तो ये तो कुछ और ही हो जाता. So that is the answer. So you have to be vigilant there and then at every stage, because once once a suit shapes up in a particular matter and the record is made at the trial court level, you can't do much at the high court level except technicalities. If the evidence is not on record, then what you will read before the high court? High court will say straight away, "Mr. Counsel, please show me where you have taken this point in the trial court." And then you keep on searching. So record, you make your brief foolproof. That is all I can say.
Thank you, sir. So Azam had another question related to the previous question which he asked, that how can the newcomers overcome the fear of presenting in open court, and how to be confident, especially while making your pleadings?
Read newspaper daily loud, or any judgment loud, alone in a room. I think because somebody suggested me actually, one former judge, he now passed away. He suggested me without even saying anything. He said most important thing, he used to practice in Supreme Court as a senior counsel after being retired from Jabalpur High Court as a Chief Justice. He said, and very simple, very plain language. He said, read aloud one judgment daily, because आपको कोर्ट में वही करना है रोज when you argue. It's a very simple advice, but if you follow, I think best possible without any expense. Otherwise, you go to some center, you pay money. I think money can be paid to somebody else then. So I think read aloud judgments on a daily basis, whatever you read. Because it's basically low self-esteem that you may have, subject to correction. But I think the basic problem would be that one. At low self-esteem, you don't think you can do it, but you can. I think.
Indeed, a very good advice. I think we all should apply this. I think it would help us gather knowledge from the judgment as well as improve our speaking skills.
Yeah, because in every court, you have to argue and you have to read your brief and judgment and whatever. So reading part, if you do on a normal basis, I think you will have some confidence. You will take some confidence from your normal routine habits. And I think the second important aspect you can do is should discuss law or judgment or whatever with your friends on a normal basis. Because discussion may see, if you sit idle and you read a judgment, you may have two queries. And if you read and sit with a friend who has already also read the judgment, then 5 queries will come into it. Because when you speak or when you write, then you will have more queries. Let's say I read these two case laws in before you all, and I have to write a publication on Commercial Courts Act. Then automatically, queries will come into picture in my head. Which was the first judgment? Which is the latest law? Which is being followed up? Which case where? Single judge, division bench. What if this? What if that? So when you speak aloud or when you write in any form, you may do so. I think queries will come, and those queries will come. Is better that those queries come early and not before the court, because in court you need to anticipate and prepare those queries from the opposite side in advance, rather than being on the caught completely unawares. So you need to read your brief and the opposite side brief and anticipate queries from their end, and also from the court. Read opposite, things from their perspective. I think so. So that will make some difference.
Thank you, sir. We have last question for today, which is by Kumar Sarthak. If you could recommend any reading material, book, or anything else other than the Bear Act, and that will explain in detail the different aspects of a commercial dispute, which you have discussed today.
I just do live law or bar and bench or SEC or Manupatra. There are publications of articles, columns always. So article columns may you will have a crystallized, summarized view of the law from where it started, from where we now. It is same for any topic. You take arbitration. You have weekly journals. You have monthly journals. You have yearly journals. Like 2021 Supreme Court journals are there on live law or bar. I think those make a lot of difference. If you go through them, see. Secondly, I normally do it. Let's say I pick up a topic. So I read the entire Bear Act, then I read the entire commentary. And in the commentary, if you carefully notice, towards the end, last 4 or 5 points in every section, IPC I'm saying particularly, substantive, you will have the topics, what evidence is required for this section to prove. How the charge will be framed for this section. What are the essential ingredient tests for this section? So if you go through that, then you will understand. Then you go beyond the basic understanding, because very, very important. Because for me, I do normally like this. I read the commentary. I give a small dictation to my steno, and I summarize the entire commentary in one go in writing. One line bracket mein case law, one line bracket mein case law. So that is very important. And he can just show. There's one folder of one particular section. I will give an example. There's one commentary research Word document. You can just open. I haven't shared that with me. Just 1 second. So maybe I can share. Maybe I can share tomorrow. So you read whatever you do it properly, and you read in full. Don't leave anything. Read around, read under, read over, read extra, read articles. So see articles and publications, you will get the clarity regarding policy, how the the law is interpreted, and till date. So you should have a complete picture. See, if you read, I give you one small example. If you read 21C, commercial dispute, you should know Because confidence, you will get confidence only when you know what is the policy, you know from when it started, what date, what was the first precedent, and what is the last precedent. So if you know the last precedent, then you will actually know the entire term or the manner of the interpretation by the courts. So then you will have a complete knowledge. And you have a complete knowledge, then you may have some more confidence compared to others. I think uh, that is important. That is how I do it. In terms of the interpretation also, for the commercial dispute, I've gone through all case laws of the High Court, major case laws, and also I've gone through a lot of case laws of the trial court, district court commercial uh, act. So there you will understand in detail, much more detail. See, if you notice, you may have seen the right, nothing more. In the trial court judgment on a commercial dispute, you pick up any judgment, and the court will discuss the evidence also. So that is very important in my view. That is very important. So trial court judgment you can read, and publications articles give you a overall holistic view. So he can do that. Articles and columns में आते रहते हैं, lot of things, and start writing. See, you can only write when you know from start to finish. For example, you start writing on commercial dispute, and you take a particular view on certain judgments, and you don't know the latest view. There's some change of the interpretation. Then your article is useless, because somebody will point out that this article doesn't contain the latest interpretation of the court. So same is with your interpretation. If you know the interpretation throughout from start to finish, then only you can say that you know something. Like I wrote an article on Negotiable Instruments Act. So I had to read all case laws, literally all case laws on that particular topic. Like there's an topic of security check. This is one of the topics. So think from a perspective that you have to write something. Then automatically queries will start to ponder.
Thank you so much, sir. Since we have come to the end of the session, I would like to take this opportunity to place on record my sincerest thanks to Advocate Rajat Mathur, sir, for gracing us with your valuable time on a Saturday morning. The knowledge gained was extremely enriching, and I'm sure all of us have a lot to take back from today's session. We have day 2 of the lecture series tomorrow. We'll look forward to having all of you with us at the same time at 11 a.m. Have a wonderful Saturday, everyone.
Thank you, everyone, for a patient listening and queries. Thank you.
Thank you, sir.
Thank you.